There are two judgments.
We don't need your lordship to tell us that. We know that.
One is on behalf of myself and Justice Arvind Kumar, Justice Satish Sharma, and Justice Rochan. We have considered all the judgments, and we find that the earlier two judgments, Rameshwar Dayal and Chandra Mohan, have not been properly considered by all other judgments. We have divided the judgment in various chapters. The first one is with regard to textual and contextual interpretation. We held that the interpretation which makes the textual interpretation match the contextual has to be preferred. A statute is best interpreted when the reason and the purpose for its enactment is ascertained. No part of a statute and no word of a statute can be construed in isolation. So we have held that the Article 233 has to be read in a whole. It can't be read in part. A combined reading of clause 1 and 2 of Article 233 of the Constitution would reveal that though the Constitution under clause 2 of Article 233 provides for a qualification for an in-service candidate for direct recruitment, it does not provide for a qualification for those who are already in service. We held that if the interpretation has sought to be given in the judgments of this court, right from Satyanarayan Singh to Dheeraj Mor, is to be accepted, it will render the first part of clause 2 of Article 233 of the Constitution redundant. We held that such an interpretation of clause 2 of Article 233 would not be permissible in law. We held that the source of appointment of all married promotees lies in clause 1 of 233. All pervasive power, and 233(2) only provides for qualification. And the word, if we accept the interpretation, then the first part will be rendered redundant. So they have held that 233 will have to be read to give meaning to the first part, and therefore the second part requires that a person to be appointed as a district judge from an advocates category has to be having a practice of 7 years. The first part says that it is not necessary, and therefore the qualifications will have to be provided in the rules framed under 233(1). Then we also held that the interpretation of the constitutional provisions cannot be pedantic. It has to be organic. A purposeful interpretation has to be adopted. If the appointment to the district judge cadre is to be made directly for the purpose of enhancing the efficiency of district judiciary, any interpretation which restricts the competition and prohibits the otherwise meritorious candidates from zone of consideration will have to be excused. The interpretation which advances the purpose of bringing in efficiency in the district judiciary and permitting a broad-based competition amongst all the eligible candidates will have to be accepted. Then we have held that the state government, in consultation with the respective high courts, will have to frame rules providing eligibility for in-service candidates to apply for the post of district judge, which should be filled by direct recruitment. We are also with that for bringing the advocates and the in-service candidates at the same level, it will be appropriate that the rules provide that an in-service candidate should be eligible for recruitment to the district judge only if he has a combined experience of 7 years as an advocate and a judicial officer. We have rejected the condition of Mr. Naidu that even after a gap of 10 years, if he completes. Then we are not inclined to accept the condition that breaking the practice of a candidate should be ignored for a person having a total of 7 years of practice. Because if such a person has practice for 5 years and thereafter he takes a break for 10 years and thereafter practices for 2 years, there will be a total disconnect with the legal profession. Then we have rejected the condition that the 233(2) provides a quota of 25% for the direct recruits. And insofar as the doctrine of stare decisis is concerned, we have held that the doctrine of stare decisis would permit an incorrect provision, incorrect law which has been laid down by so many judgments and totally misconstruing the two constitutional bench judgments. It will perpetuate illegality which has been in existence for 40 years. So merely because the wrong law has been held for 40 years cannot be a ground to interpret the Constitution in a proper manner. We have held that an injustice was meted out to the members of the judicial service, thereby depriving them from practicing in the selection process for the past post of district judges by a direct recruitment. Having found that the law laid down by this court in the aforementioned cases does not correctly interpret the provisions of Article 233, if we fail to correct the legal position, we will be perpetuating the injustice that has been meted out for decades. Therefore, rejected the argument on stare decisis as raised by the parties opposing the proposition. We have clarified that the judgment will be applicable only from the date of the judgment, and in no case any selection process completed or any appointments made prior to this judgment would be affected, except in cases wherein any interim orders were passed by the High Court or this court. In such cases, the issue would now be governed by the orders to be passed by the bench hearing the matter. We have also interpreted the rules framed by the Bar Council of India. We have held that on being appointed as a judge, the advocate only suspends his right to practice, and his role continues to be his name continues to be on the roll. And therefore, in view of Rameshwar Dayal, though the name was not there, by deeming fiction, the court found that in those two cases, in case of those two persons, they are deemed to be on the roll. We have sought support from those observations. In the result, we have answered the questions as under. Judicial officers who have already completed 7 years. So it was not necessary to answer the question, but since we had framed, we are answering all the questions. Judicial officers who have already completed 7 years in bar before they were recruited in the subordinate judicial service would be entitled for being appointed as a district judge, additional district judge, the selection process for the post of district judges in the direct recruitment process. The eligibility for appointment as a district judge, additional district judge, is to be seen at the time of application. Though there is no eligibility prescribed under Article 233(2) for a person already in judicial service of the union or of the state for being appointed as a district judge, in order to provide a equal level of playing field, we direct that a candidate applying as an in-service candidate should have 7 years combined experience as a judicial officer and an advocate. A person who has been or who is in judicial service and has a combined experience of 7 years or more as an advocate or judicial officer would be eligible for being considered and appointed as a district judge, additional district judge under Article 233 of the Constitution. In order to ensure level playing field, we further direct that the minimum age for being considered and appointed as a district judge, additional district judge for both the advocates and the judicial officers would be 35 years as on the date of the application. It is held that the view taken in the judgments of this court right from Satyanarayan till Dheeraj Mor, which takes a contrary view to what has been held herein above, do not lay down the correct proposition of law. The reference is answered accordingly. Consequently, all such rules framed by the state government in consultation with the high courts, which are not in accordance with the aforesaid answers, shall stand quashed and set aside. It is directed that all the state governments, in consultation with the high courts, shall amend the rules in accordance with what has been held by us herein above within a period of 3 months from today. The registry is directed to obtain the necessary orders from the Chief Justice of India on the administrative side to place the matters before the appropriate bench for deciding the same in the light of what has been held herein above. Before we conclude, we place on record our sincere appreciation for all the learned senior counsel, to also their junior counsel for assisting us in such a meticulous manner. Our task was made easier by the assistance rendered by them. We also place on record our appreciation for all the learned counsels for strictly adhering to the timeline, as a result of which this court was able to complete the hearing in the prescribed time. We would be remiss if we do not place on record our appreciation for the nodal counsel in collating all the material in an organized manner.
So I just read only the 11th. Used in Article 233(2) of the Constitution must be read as qualified. Thus, a person who has been an advocate or a pleader for not less than 7 years, along with the recommendation of the High Court, is one qualification. One of qualification, a person in the judicial service is one qualification, the person is other qualification. Both of these qualifications are nothing but mere gateways for being appointed to the post of a district judge, facilitating a threshold for entry. However, there is no bar for the High Court to fix a qualification for the persons in the judicial service with the approval of the governor. These qualifications are mainly meant only for consideration for appointment, subject to successful completion of the recruitment process. My conclusion. While interpreting a constitutional provision, a court of law must be conscious not to violate the basic structure of the Constitution, and it is duty bound to give it a vibrant and organic interpretation. Article 14 of the Constitution forms an integral part of the basic structure. Though it provides for equality before law, it allows for reasonable classification based upon intelligible differentia, having a personal nexus to the object sought to be achieved. Therefore, construing Article 233(2) of the Constitution to be a provision meant only for a category of an advocate or a pleader would certainly be violative of Article 14 of the Constitution for the purpose of its interpretation. In other words, a contra view would amount to creation of a quota for an advocate or a pleader. An absolute bar on persons in the judicial service would certainly prevent meritorious candidates from competing for vacancies earmarked for the direct recruitment, which would be an affront to the constitutional spirit. A vibrant and qualitative judiciary fosters greater trust in the institution. Thus, it is vital to bring a solid foundation. Maintaining and enhancing the quality at the bottom of the judicial pyramid would strengthen the faith of the public in the subordinate judiciary, which in turn would reduce the filing of appeals before the High Court and Supreme Court, and therefore considerably reduce the overall pendency. Building a strong foundation and ensuring that the base is of pristine quality is only possible with the best talent when the best talent is attracted. Letting go of the emerging talent by not identifying and nurturing them at the earliest would lead to mediocrity as against excellence, which would weaken the foundation and undermine the entire judicial structure. It is obvious that greater competition would result in better quality. Excluding a group of persons from competing for a post which is meant to serve the public would certainly be unconstitutional when the Constitution itself facilitates such participation. It is my fervent hope that our judgment empowers the institution to emerge stronger and maintain the highest standard of justice, as it is in the interest of the institution that must prevail above all.
We are grateful to all of you for your valuable.
We are very grateful to your lordship.
As an honor.
Deeply obliged, deeply obliged.
Why is Mr. Varnapalli standing at the corner?
But the individual appeals will be listed.
Yes.
Individual appeals will be.
No, no,
Yes.
you are not here when the
I
judgment was.
missed that.
Waiting
How many matters are there?
wait for last 6 years.
No, no, how many matters are there?
20, 20, 29, 30.
29.
29, 30.
Petitions are number.
It can be over in 1 hour. Madam.
But they
It
will.
can be over in
Hardly
1 hour.
take any time, Lord, with your lordship judgments, they are all be over within minutes.
Yeah, they should be over within an hour or so. We will
Yes,
Within
so far
an
as
hour.
somewhere.
at least the ones I am appearing, they are all covered. They are just to be, there's just.
Maybe on some Monday, we'll keep it in the second half. So
Yes, yes,
Very
yes.
well.
so that all of them can win.
Yes.
Either of, any of, either this combination or this combination. Or we will do 50-50.
Grateful.
There will be a gift. Before Diwali, it will be a gift for the
आगे जा रहा हूँ।